A very major role is played by the pre-trial judge. Why? Because, first of all, he has to confirm the indictment. Confirm, or he may have some doubts, he may ask the prosecutor to revise, in a way, to strengthen the indictment and so on. But in the end, he should confirm the indictment and issue arrest warrants or summonses to appear, depending on what the prosecutor and the pre-trial judge decide to do. Then the pre-trial judge will request the prosecutor to pass on to the defense all the probative material, so evidence collected by the prosecution. And then the pre-trial phase starts. In this phase, first of all, the pre-trial judge has to select the victims, because all those who claim to be victims of a particular crime, which has been, of course, charged in the indictment, they will come forward, and the pre-trial judge will have to sift through the various victims to see whether they meet all the requirements of a statute and rules of procedure and evidence, and then he will decide whether or not they should come forward, take part in the proceedings, and also he will see to it that the head of the particular unit in charge of the victims participating in the proceedings appoints defense counsel or legal representatives for those victims. In this pre-trial phase, which should last between 4 and 6 months, there is an exchange of documents between the defense and the prosecution, and also pre-trial motions may be filed by, say, the defense. Those motions normally go to the trial chamber, or some of them may be already decided upon by the pre-trial judge. So therefore, at this stage already, the trial chamber comes in, and so a couple of months after the initiation of the whole proceedings, and may decide upon those motions, which are preliminary motions. Once all this stage has been gone through, then the trial proper starts. At that stage, of course, the trial chamber will go through the evidence, call witnesses and so on, and then this will lead to the acquittal or conviction of the defendants.